He had done everything by the book. Valid permit, registered firearm, not a single criminal charge in his entire life. He had carried responsibly for over 2 decades and never once had a reason to think the gun sitting legally in his center console would become the center of a legal nightmare. Then a routine traffic stop changed everything. A broken taillight. The kind of stop that should have been over in 7 minutes with a warning and a wave goodbye. Instead, it ended with his vehicle searched against his will, his firearm seized, and 3 years of legal battles that drained his savings and consumed his life. Not because he was a criminal, not because he had broken a single law, but because he did not know the rules had changed. And more importantly, he did not know what to say and what not to say when that officer was standing at his window. Surprised, the Supreme Court of the United States just issued a ruling that directly affects every single person who carries a firearm in a vehicle. 9 justices, 0 dissents, the most unified decision on gun rights in a generation. And if you keep a gun in your car, or you know someone who does, you need to understand what this ruling says, what it protects, and exactly where it will fail you if you do not handle your next traffic stop the right way. Because this ruling is not a magic shield. It is a legal tool, and like every tool, it only works if you know how to use it correctly. Before we get into the ruling itself, one thing. This channel covers Supreme Court decisions, new gun laws, and changes to your rights the moment they happen, not weeks later when you stumble across it in a comment section, not after you have already needed the information and did not have it. If that is the kind of update you want in your corner, subscribe right now and hit the notification bell. 2 seconds. It costs you nothing, and the next ruling that affects your life will be waiting for you the moment it drops. Now let us talk about what the Supreme Court just said and what it actually means. The next time you are sitting on the side of a road with a gun in your car and a badge at your window. To understand why this ruling matters and why it matters to you specifically, today, before your next drive, you need to understand the problem it was built to fix. The United States Constitution gives every American 2 protections that should never be in conflict with each other. The Second Amendment gives you the right to keep and bear arms. That right is foundational. Millions of Americans exercise it every single day, legally, responsibly, and without incident. It is one of the oldest and most clearly stated rights in our founding documents. The Fourth Amendment gives you the right to be free from unreasonable searches and seizures. No government agent can go through your vehicle, your home, or your personal belongings without either a warrant or a specific legally defined justification. That protection is equally foundational. 2 constitutional rights, both clear, both settled, and for years, quietly, on roads across every state in this country, those 2 rights had been crashing into each other in ways that most gun owners never discovered until it was far too late. Here is the collision. When an officer pulls you over and learns you have a firearm in your vehicle, what does that information legally authorize him to do next? Can he search your car based on the gun alone, even if that gun is completely legal, even if you have a valid permit, even if you have done absolutely nothing wrong and there is 0 evidence of criminal activity anywhere at that stop? Courts in multiple states were beginning to answer that question with yes. The reasoning being constructed in those lower courts went like this. Firearms are inherently dangerous. A firearm in a vehicle creates an inherently unsafe situation. Therefore, the officer has an automatic right to search regardless of whether any crime has been committed. Follow that reasoning to its conclusion, and you arrive at something that should alarm every gun owner in America. If the mere presence of a legal firearm gave law enforcement automatic search authority, then exercising your Second Amendment right would simultaneously eliminate your Fourth Amendment right. You could not have both. You would be forced to choose between them. That is not what the Constitution says. That is not what any honest reading of those 2 amendments has ever meant. But it was happening in real cases to real people, and it was spreading, until a case reached the highest court in the land that could not be ignored. Cases like this one do not begin in marble courtrooms with reporters and cameras. They begin exactly where yours would, on the side of a road. A driver pulled over for a minor traffic infraction. Nothing serious. The kind of stop that should be resolved in under 10 minutes. The officer approaches the window. The driver is calm, hands visible, cooperative from the first second. He discloses clearly and without hesitation that there is a legally owned firearm in the vehicle. No erratic behavior, no suspicious movements, no indication of criminal activity of any kind. By any objective measure, this is a model interaction between a responsible gun owner and law enforcement. The officer looks at the situation and makes a decision. He decides the gun is enough, that the presence of a firearm, regardless of its legality, regardless of the driver's complete cooperation, regardless of the total absence of any other red flag, justifies a full search of the vehicle. The driver objects. Calmly, clearly, he states he does not consent to a search. The search happens anyway. The case moves through the courts. And here is the part that should genuinely disturb every gun owner watching this. The lower court sided with the officer. They ruled that under those circumstances, the presence of a legal firearm alone was sufficient legal justification for searching the vehicle. They essentially concluded that being a gun owner made someone suspicious enough to forfeit their privacy rights. One constitutional right used as the justification to override another. Then it reached the Supreme Court of the United States. And what happened there is something that almost never occurs, particularly on anything touching firearms and law enforcement authority. 9 justices, every ideological corner of that bench, from the most conservative to the most progressive. They looked at this situation together, they deliberated, and they arrived at the exact same conclusion. 9-0. No dissents, no partial concurrences on narrow technical grounds, no splits. A unanimous across-the-board ruling from the highest court in the land. When 9 Supreme Court justices agree unanimously on anything involving guns and police authority, you pay very close attention, because that level of agreement does not happen by accident. It means the constitutional line being drawn is not subtle, not ambiguous, and not open to reinterpretation by lower courts trying to work around it. It is clear enough that 9 very different legal minds all landed in exactly the same place. Here is the core holding of this ruling. Every single word matters. The mere presence of a legally possessed firearm in a vehicle does not by itself constitute probable cause to search that vehicle. Let me translate that into plain language. Legal gun ownership is not suspicious activity. Lawful carry is not evidence of a crime. Law enforcement cannot treat either of those things as though they are. The court delivered a direct, unambiguous message to every law enforcement agency in the United States. You cannot use a citizen's exercise of one constitutional right as the justification to strip them of another. The Second Amendment and the Fourth Amendment exist together. They stand together. A law-abiding gun owner is entitled to both at the same time, without condition, without having to choose between them. The court's language on this point was precise and unmistakable. Armed does not mean criminal. 9-0. Now here is where most people who hear about this ruling make the mistake that turns a genuine legal protection into a dangerous false sense of security. You are thinking this ruling is a force field, that the next time an officer approaches your window, you have a 9-0 Supreme Court decision protecting you and the conversation ends there. It does not end there. Treat this ruling as a complete and absolute shield, and it will fail you, possibly at the worst possible moment. The court ruled that a legal firearm does not by itself create probable cause. Those 2 words, by itself, are doing the heaviest lifting in this entire ruling. The moment other factors enter your traffic stop, the legal picture changes, and it changes fast. There are 3 specific trapdoors built directly into this ruling. Know them cold before you ever need them. The first trapdoor. This ruling protects people who legally possess a firearm. It does not protect prohibited persons. If you are legally barred from possessing a firearm due to a prior felony conviction, a domestic violence restraining order, or any other disqualifying factor under state or federal law, this ruling provides you zero protection. The gun is not a neutral detail in your situation, it is evidence of a crime. And furthermore, if the officer has any reasonable, articulable suspicion that the firearm in your vehicle is not legally possessed, the analysis changes immediately. An officer who suspects you should not have that gun does not need additional probable cause to investigate further. The suspicion of unlawful possession is itself the probable cause. This ruling works only when your legal status is completely clean. If there is any question at all about your right to possess that firearm, this ruling does not apply to you. The second trapdoor. This is where many genuinely responsible, completely law-abiding gun owners get caught, and it is entirely avoidable with basic preparation. Many states have specific laws governing exactly how a firearm must be stored or transported inside a vehicle. Some require the firearm to be unloaded. Some require it to be secured in a locked container. Some restrict which area of the vehicle it can be located in. Some rules change depending on whether or not you hold a valid carry permit. If an officer approaches your window and observes a firearm stored in direct violation of your state storage statute, this 9-0 ruling will not help you. The officer is not searching based on the presence of a gun. He is searching based on specific, observable, articulable facts indicating a criminal violation of a storage law. The gun itself may be perfectly legal. The manner of storing it is not. And that distinction, while it sounds like a technical legal detail sitting here reading about it, is the difference between this ruling protecting you completely and this ruling having absolutely no relevance to your situation whatsoever. Know your state's firearm storage and transport requirements before you put the car in drive, not after. Not when you are sitting on the shoulder trying to remember something you read somewhere 6 months ago, before you leave the driveway. The third trapdoor. This ruling stops officers from using a legal firearm as the only justification for a search. It does not stop them from using it as one factor among several. Picture this scenario. You are pulled over. You have a legal firearm, but your passenger is visibly nervous and giving short, evasive answers to basic questions. There is an odor the officer identifies as a controlled substance coming from inside the vehicle. You are providing inconsistent information about your destination and recent activity. The officer is not going to document that he searched because of the gun. He is going to document that he searched because the gun, combined with the odor, combined with the behavior, combined with the inconsistent statements, collectively established probable cause, and he may be legally right. This ruling did not abolish the automotive exception to the Fourth Amendment. It did not restrict officers from investigating genuine indicators of criminal activity. What it stopped, specifically and precisely, is the use of a lawful firearm as the sole and only justification for a vehicle search. Every other factor at that stop still matters. Every other factor can still be used. That line is where this ruling does its real work, and also where it has its real limits. Now we get to the single most dangerous moment of any traffic stop involving a firearm. Not when the officer first approaches your window, not when he spots the gun, not when he asks for your license and registration. The most dangerous moment is when the officer realizes he does not have enough to legally justify a search, and he tries to get you to hand him permission anyway. He will say something that sounds completely professional, completely reasonable, and completely routine. Something exactly like this. Since you have got a firearm in the vehicle, for your safety and mine, do you mind if I just take a quick look through the car? He is polite. He sounds like he is simply doing his job. Every instinct you have as a cooperative, law-abiding person who genuinely has nothing to hide tells you to say yes, to prove you are not a threat, to show you are one of the good ones. Do not say yes. The moment you say yes, the moment you say, sure, go ahead, I have got nothing to hide, this 9-0 Supreme Court ruling becomes completely irrelevant to your situation. You have handed the officer a blank check. Glove box, trunk, center console, your personal bags, all of it. Consent overrides the court. This is not a legal technicality buried in fine print somewhere. It is the foundational principle of Fourth Amendment law. If you voluntarily consent to a search, you have waived your protection, and that waiver cannot be undone in a courtroom, not even with this ruling directly behind you. This ruling is a shield. Consent hands that shield to the officer the moment the word yes leaves your mouth. Here is your complete protocol, step by step, from the moment those lights appear in your mirror to the moment the stop ends. This is not general advice. This is a specific sequence built around exactly what this ruling protects and exactly where it does not. Step 1. Pull over immediately and correctly. Signal. Slow down smoothly. Move to the right shoulder without hesitation. Do not look for a more comfortable spot further down the road. Do not drive an extra block because you think the lighting is better ahead. Pull over promptly and completely. A delayed or uncertain pullover creates suspicion and tension before a single word has been exchanged. And you do not want to be managing suspicion before the officer has even reached your window. Step 2. Control every variable in that environment before the officer gets to your door. Turn off the engine. Roll down your driver's side window fully. If you have tinted windows anywhere in the vehicle, roll those down as well. This removes the visual uncertainty that makes officers tense before they have said anything to you. If it is nighttime or low visibility conditions, turn on your interior dome light. Then place both hands flat on top of the steering wheel and keep them there. Do not reach for your registration. Do not reach for your wallet. Do not open your glove box. Do not adjust anything. Sit completely still with your hands where the officer can see them and wait for him to come to you. Movement inside a vehicle before an officer reaches the window is one of the primary reasons routine stops escalate into something more. Remove that variable entirely before it becomes a factor. Step 3. Speak before you reach for anything. When the officer asks for your license and registration, your first response should not movement. If your firearm is anywhere near your document storage area, and in many vehicles the registration lives in the glove box right next to where people keep a gun, an unannounced reach toward that location is exactly how calm interactions become dangerous situations in seconds. Before you move anything, speak. Officer, I want to let you know I have a legally owned firearm in the vehicle. I have my permit with me. Before I reach for my documents, how would you like me to proceed? That approach accomplishes 3 things simultaneously. It demonstrates complete cooperation. It eliminates surprise, which is the single greatest source of tension at any vehicle stop. And by asking the officer how he would like you to proceed, you place the next decision in his hands and signal clearly that you are a prepared, responsible gun owner following a deliberate protocol, not a threat, not someone with something to hide. The vast majority of officers respond to this approach immediately and positively. It reframes the entire interaction before it has a chance to go sideways. Step 4. Know your state's duty to inform law before you ever need it. Some states legally require you to inform an officer immediately upon being stopped that you are carrying a firearm. Others have no such requirement. Some require disclosure only if the officer asks you directly. This varies significantly from state to state, and it matters enormously. If your state mandates immediate disclosure, comply without hesitation and without elaboration. If your state does not require disclosure and the firearm is not visible, you have no legal obligation to volunteer that information unprompted. But here is the part that gets people into serious trouble when they think they are being smart. If an officer asks you directly whether you have a firearm in the vehicle and you lie, you have potentially just committed a criminal offense on top of whatever else is happening at that stop. A single lie to a law enforcement officer can transform a routine traffic stop into a criminal situation faster than almost anything else. If asked directly, answer honestly. Know your state's specific law. Do not guess. Step 5. Refuse consent calmly, briefly, and without apology. When the officer asks if he can look inside your vehicle, and he may ask, this is the moment your rights either protect you or they do not. Do not argue. Do not lecture. Do not reference the Supreme Court ruling or start explaining probable cause like you rehearsed it from a video. Simply say, I would prefer not to consent to a search. That is it. If he responds with something like, if you have nothing to hide, why not just let me look? Recognize that line for exactly what it is. It is psychological pressure. It is specifically designed to make refusal feel like an admission of guilt. And it works on most people because we are trained from childhood to cooperate with authority and demonstrate our innocence by opening everything up. Respond calmly. You can say, I always exercise my rights. I am not consenting to a search. Then stop talking. You are not on the side of that road to win an argument with the officer. You are there to protect your legal position so that if something goes wrong, you can win later in a courtroom with an attorney sitting beside you. Step 6. Use silence as a deliberate and intentional legal tool. Silence is not weakness. Silence is not an indicator of guilt. Silence is a protected exercise of your Fifth Amendment rights, and it is one of the most powerful tools available to you at a traffic stop. When the officer is not asking you a direct, required question, you do not need to fill the quiet with nervous explanation. You do not need to answer, where were you coming from tonight? You do not need to answer, is there anything else in the car I should know about? You do not need to answer, you seem a little nervous. Everything okay? You can remain calm and quiet. The reason this matters is straightforward. Most people who end up in serious legal trouble at a traffic stop did not get there because the officer discovered something without their help. They got there because they talked their way into providing the probable cause the officer needed to search. Every nervous sentence you volunteer, every unprompted explanation you offer, trying to sound innocent, every extra detail you add because the silence feels uncomfortable, each of those is a potential building block toward the legal justification for a search that the ruling you just learned about was designed to prevent. Silence removes every one of those blocks from the table. Use it deliberately and without guilt. Step 7. If the search happens anyway, do not physically resist under any circumstances. If the officer proceeds to search your vehicle after you have clearly, calmly, and explicitly refused consent, your job is not to physically stop him. Your job is to create the clearest possible legal record of what is happening. State calmly, at a volume his body camera can capture, I am not consenting to this search. Say it once, then stop. Do not repeat it. Do not raise your voice. Do not interfere with the search in any physical way. Step back if possible, remain calm, and let the officer's actions become the complete legal story of what happened at that stop. Every action taken by law enforcement after an unlawful search began is subject to legal challenge. Every piece of evidence discovered in a search that lacked proper justification becomes potentially suppressible in court. An unlawful search that is challenged and thrown out in court is a legal victory. A confrontation on the side of a road is not. Your composure at that moment is not weakness. It is the single most important thing you can do for your legal case, and any attorney will tell you that afterward. Step 8. Document everything before you drive 5 miles from that location. The moment the stop ends and you are safely away, pull into a parking lot or gas station and write down everything that happened while the details are still sharp and accurate. Write down the exact time the stop began and ended. Write down the exact location. Write down the officer's name and badge number if you have them. Write down the specific words exchanged during the stop as close to verbatim as you can recall them. Write down whether you consented to a search or explicitly refused. Write down what justification, if any, the officer offered for searching the vehicle. Write down what was or was not found. Write down the names and contact information of any witnesses. Human memory is not a reliable recording device. It degrades rapidly and it does so selectively. Specific contemporaneous documentation written down within minutes of an event is what attorneys use to build winning legal cases. Vague, general impressions recalled weeks later under stress are what cases get lost on. Here is the bottom line on everything you just heard. The Supreme Court ruled 9-0 that the mere presence of a legally possessed firearm in a vehicle does not by itself give law enforcement probable cause to search that vehicle. That is a genuine, historic, hard-won legal protection for every law-abiding gun owner in this country. Armed does not mean criminal. The Second Amendment and the Fourth Amendment stand together. But this ruling only protects you if your legal status as a gun owner is completely clean. It only protects you if your firearm is stored in compliance with your state's specific storage laws. It only protects you if no other factors at your traffic stop give the officer independent grounds for a search. And it only protects you if you do not hand it away the moment an officer politely asks if he can take a quick look. Know your state's storage laws. Know your duty to inform. Know your protocol before you need it. Refuse consent calmly and without apology. Use silence as the legal tool it is. And if a search happens anyway, stay calm, state your refusal once for the record, and let the law do its work in a courtroom where it actually belongs. The man at the beginning of this story had the law on his side. He just did not know how to use it. Now you do. Share this with every gun owner you know because most of them are carrying right now without this information. Subscribe and hit the notification bell because the legal landscape around your gun rights is moving faster than it ever has, and the next ruling that matters to you is coming sooner than you think.